Join ForumIAS Academy, trusted by hundreds of toppers, including IAS Rank 1 𝐂𝐡𝐚𝐬𝐫𝐢𝐻𝐵.
Good evening, aspirants. Welcome to the Hindu news analysis discussion brought to you by ForumIAS for the date 30th of September 2023. These are the list of news articles for today's discussion. We will be covering 5 topics from governance, polity, and a topic from international relations. Alongside this, we will also be discussing 2 previous year prelims questions at the end of the discussion. So with this straight away, let us move to our first article. First article, push for more women, this time in the police. We all know, right, the constitutional 128th Amendment Bill 2023 has been passed by both the houses of the parliament, and this bill provides for 1/3 of total seats in Lok Sabha as well as in the legislative assembly of every state to be reserved for women for next 15 years. Additionally, this reservation will be extended to seats reserved for SC and ST in Lok Sabha and state legislative assemblies. And moreover, we should know that the representation of women members of parliament in the current Lok Sabha is around 14.4% compared to just around 5% in first Lok Sabha in the year 1952. So, in order to increase the representation of women even further, the 128th Constitutional Amendment Bill was introduced. However, as the amendment has certain red flags, experts are of the opinion that this amendment can be implemented only by the general elections of 2029 and not before that. And provided Census 2021 is also taken up soon and the process of delimitation is carried out without any delay. Otherwise, implementation will be delayed even further till the general election of 2034. By considering the recent constitutional amendment, the author says that such affirmative actions from executive could improve women's representation, but there is no direct link between the number of legislators and the strength of law enforcement agency. In the para reservation actual availability in the police, the author says most states have the policy to fill up 30 to 33% of the vacant post with women in their police forces through horizontal reservation. That is, if the minimum reserved vacant posts are not filled up in each category of SC, ST, OBCs and unreserved with women on merit, then women candidates are pushed up in the list to make up for the gap. So, the representation for women in the state armed police forces is restricted to just around 10% in some states. Adding to that, women are generally recruited against notified vacancies after permission is granted by the government to fill up vacancies. To substantiate his points, he quotes the data from Bureau of Police Research and Development. That is data on police organization, which is a publication by the Bureau of Police Research and Development. This data shows that while the total available strength of state police forces increased by around 7.48% in last 5 years, the representation of women in the state police increased from 1,40,000 to 2,17,000 in the same period, which is just around 10.47% of total available workforce in the year 2021. Previously, in the year 2017, the representation of women was around 7.3%, whereas in 2021, the representation has increased by just around 3%. Though the data for the year 2021 has not been published, the Minister of State of the Home Affairs informed the Rajya Sabha in February 2023 that the representation of women in police force remained around just 11% of the state police forces. That is why the author says there is no direct link between number of women legislators and their strength in law enforcement agencies. Also, according to the details published by the Bureau of Police Research and Development, few states such as Kerala, Mizoram and Goa do not have a policy of reservation for women in police force, but women's representation in these states varies around 6% to 11%. For instance, Bihar provides 35% representation for women and 3% for backward caste women. But the actual number of women in the police force is about 18% only. However, Chandigarh has a maximum percentage of women, which is around 22% in their police force, while Jammu and Kashmir has the minimum of 3.3% in the total strength of police forces. Here, we have to know that though the Ministry of Home Affairs has repeatedly asked states to increase the representation of women in police forces to 33%, the actual availability remains low. Many states do not even have a permanent police recruitment board and do not have a free hand to undertake recruitment at regular intervals. Another matter of fact is that criminal law and criminal procedures fall on the concurrent list. So the central government has made various amendments in these laws. Why? Because certain reports and statements ought to be mandatorily recorded by women police officer. Moreover, arrest and search of women accused must be done by a women police officer only. Know that according to National Crime Records Bureau data, about 10% of total crime defined under the Indian Penal Code was committed against women, and about 5.3% of total arrested persons in 2021 were women only. Therefore, the available workforce is insufficient even in dealing with cases that are related to women. Also know that women are needed for law and order and day-to-day duties as well. Additionally, acts like Protection of Children from Sexual Offences Act, which is the POCSO Act, has further enlarged the scope of women recruitment in police forces. Here, the author highlights the actions undertaken by union government to alleviate the problems listed above. See, police being a state subject in the 7th schedule of the Constitution, the implementation of police reforms remains primarily a concern of the state. And so, the Ministry of Home Affairs began providing financial incentives to state governments that implement police reforms to a satisfactory level. In that, merging women police with the regular police was one such reform. Similarly, though the establishment of police recruitment board was another such reform, many states were not enthusiastic about implementing this and consequently did not get any benefits from the central government as well. Adding to that, the satisfaction level with family quarters was only about 30%. As a solution to the various problems listed before, the Ministry of Home Affairs also provided a special grant to encourage states to establish women desk in every police station. But there are not enough women personnel to handle them in the districts. Then the Ministry of Home Affairs also has a special provision in the modernization plan to build separate toilets for women staffs, ensure creche facilities for children in every police station, which is sanctioned now. So, as a whole, efforts should be made to encourage more women to join the police force. But for this, a conducive environment and basic infrastructure are a minimum necessity. So, as a suggestion, the author says a uniform police act for the entire country may help the center frame uniform standards for women police. And additionally, every state should have a recruitment board to ensure recruitment on a regular basis. Thirdly, he says a special drive should be launched by all states and union territories to recruit more women and increase their representation in the police force, just as the 128th Amendment for Women in Legislature would do in the future. So this is the opinion which is put forward by the author. So in this, we dealt about the representation of women in the law enforcement bodies and also the need and the way forward. So with this, let us close this topic and move to the next topic. Second topic, Global Dispute Settlement, India and Appellate Review. In this initial para, the author talks about the dispute settlement system of World Trade Organization that has been stalled for long. Here, the US has not allowed the appointment of experts to the appellate board. And so, the mechanism has been rendered non-functional since the year 2019 due to lack of quorum of adjudicators who are needed to hear appeals. And it has deep implications for the functioning and effectiveness of the WTO as well. Even at the recent G20 nations trade, investment and industry ministerial meeting, trade ministers discussed ways to strengthen the WTO dispute settlement mechanism and make it more accessible and efficient. Also, the World Trade Organization has been the cornerstone of the multilateral rules-based global trading system since its inception in the year 1995. Presently, all three of the organizations function, such as providing a negotiation forum, then monitoring of trade policies and resolving disputes between its 164 members, are facing challenges. In the current logjam at the dispute settlement mechanism, the WTO faces a make or break moment. So, while the future of the WTO appellate process is uncertain, another area of international law witnessing the formative stages for an appellate process is the international investment law through investor-state dispute settlement. Firstly, know that the investor-state dispute settlement, which is also called as ISDS, is an ever-present component of bilateral investment treaties. The ISDS today is the principal means to settle international investment law disputes. As a matter of fact, know that till the month of Jan 2023, nearly 1250 ISDS cases have been initiated, and India has a mixed history with investor state dispute settlement with 5 adverse awards, while 4 were in favor of India, and several cases are pending before the ISDS. But however, a critical structural facet of ISDS mechanism is that it operates through ad hoc or one-off arbitration tribunal without any appellate review. In international investment law, hundreds of ISDS tribunals operating under different arbitral institutions have on several occasions offered diverging interpretations of the same treaty provisions. Likewise, these tribunals have reached opposite conclusion despite interpreting and applying the same treaty to the same facts. So, the absence of an appellate review mechanism in ISDS has often led to inconsistency and incoherent decision that is overlapping the landscape of international investment law. This has caused instability and improbability for states as well as foreign investors, making the regime chaotic. So, an appellate review mechanism will allow for rectifying errors of law and harmonizing diverging interpretations. Additionally, it will have the power to uphold or even reverse the decision of first tier tribunal and thus bring consistency and coherence. This will in turn infuse predictability and certainty into the ISDS system. Secondly, an appellate mechanism will also be better than existing mechanisms such as the annulment proceedings, which only apply to arbitration that are administered by the International Center for Settlement of Investment Disputes. Further, such annulment proceedings can only address limited issues such as the improper constitution of an arbitration tribunal or corruption, but cannot correct errors in the legal interpretation. Whereas the appellate mechanisms will be superior in setting the ISDS award aside on limited procedural grounds in the court at the seat of arbitration. So, knowing the benefits of appellate mechanisms, discussion on creating an appellate review mechanism or ongoing at the United Nations Commission on International Trade Law. And know that although India has not made a formal statement on this issue, India presumably supports the idea of an appellate review in the ISDS. This is inferred in such a way because Article 29 of Indian Model Bilateral Investment Treaty talks about the need for an appellate review in ISDS. And given India's concern about inconsistency and incoherence in the ISDS system, supporting the creation of appellate review mechanism will be in India's interest. As a conclusion, we can say that in addition to all these alternatives, India should also push for restoration of WTO appellate body towards achieving the goal of fully and well-functioning dispute settlement system at the WTO. So that is what is mentioned in the article. So from this article, we saw about the current status of appellate board of WTO as well as the purpose of investor-state dispute settlement and the need for an appellate review mechanism in it. So with this, let us close this topic and move to the next topic. Third article, Kaveri dispute. CWMA upholds panel's decision. The news is that the Kaveri Water Management Authority upheld the decision of Kaveri Water Regulation Committee asking Karnataka to release 3,000 cusecs to the state of Tamil Nadu. Recently, the Tamil Nadu government approached the Supreme Court asking it to intervene and to make Karnataka immediately release 24,000 cusecs from its reservoirs. Besides this, the Tamil Nadu government wanted Supreme Court to ensure the availability of the specified quantity of water at Biligantulu on interstate border for the remainder of month. This is the news here. From mains angle, we shall know the reasons for persistence of interstate water disputes. First, then we shall discuss about the Kaveri water issue, and then let us see the way forward. First, the reasons for persistence of interstate water disputes. Firstly, the legislative powers concerning water have been distributed between the union and state governments. Here, the idea has been to ensure optimum utilization while balancing the interest of the states. However, this approach of imprecise distribution of power between the union and the states has created federal jurisdictional ambiguity. Secondly, a big limiting factor is the lack of effective authority for enforcing the orders of tribunals. The tribunals can only make an award and it cannot make it binding. And moreover, the tribunals also lack the ability to punish for its contempt. So these are the 2 points which are foremost important reasons for the persistence of interstate water disputes. Thirdly, Article 262 provides that the Parliament may by law prevent the Supreme Court or any other court from exercising jurisdiction in interstate water disputes. But however, in the Article 136, the Supreme Court can hear the appeals against the orders of tribunals. Thus, the SC remains the adjudicatory body along with the tribunals, creating an institutional ambiguity. Fourthly, the critics of system argue that members of tribunals created for adjudicating the interstate water disputes have been predominantly from the judiciary. This has led to lack of multidisciplinary approach to dispute settlement, and they also say there is not much difference between the tribunal and the bench of Supreme Court because of this. Fifthly, there have been excessive delays in establishing tribunals and making awards. The right to have a dispute referred to tribunal under the Interstate Water Disputes Act is based upon the union government's determination. So that leads to excessive delays in establishing tribunals and making awards. Sixthly, given that agriculture constitutes the primary economic activity in many parts of the country, water is a contentious issue. And so interstate disputes are exploited for political mobilization and electoral benefits. Because of this, most often, state governments have rejected the awards of tribunals. Seventhly, there is a lack of data regarding water flows, seasonal variations, etc., which results in ambiguity regarding the availability of water, surplus water for sharing, etc. In addition, seasonal variations in monsoonal rainfall sometimes create shortage of water. So we can see state governments argue that there is no surplus water to be shared. Now coming back to the Kaveri river water issue, see, the Kaveri water disputes is an interstate water dispute between the states of Karnataka, Tamil Nadu, Kerala and the Union Territory of Puducherry. But the sharing of Kaveri water has been an area of contestation between Karnataka and Tamil Nadu often. See, the Kaveri water dispute has its root in the agreement which was signed back in the years 1892 and 1924 between the then British ruled Madras Presidency and the princely state of Mysore. But in the year 1970, a fact-finding committee was set up to figure out the situation on ground. After submission of the report, the states reached an agreement in the year 1976. However, later when Tamil Nadu got its new government, it refused to give consent to terms of agreement, which led to fresh disputes. Instead, in the year 1986, Tamil Nadu government appealed the central government to constitute a tribunal for solving the issue under the Interstate Water Disputes Act. Later in the year 1990, following a Supreme Court order, the center constituted Kaveri Water Disputes Tribunal to resolve the water sharing dispute between Karnataka and Tamil Nadu. So this is the history behind the interstate water dispute which is concerned with the state of Karnataka and Tamil Nadu. Now let us see what should be the approach towards settling interstate water disputes. Firstly, the Sarkaria Commission has suggested that awards of tribunals be given the same weight as the Supreme Court judgment. Secondly, the government's inability to properly handle water-related disputes is reflected in high number of appeals to Supreme Court. Some experts suggest that the appeal to Supreme Court should only be on procedural aspects. Then the awards based on experts' opinion should not be questioned in the court. Thirdly, there is a need to establish a time frame for constituting the tribunal by the union government. Tribunals should also try to avoid unnecessary delays in giving awards. Fourthly, the Interstate Council can be rejuvenated to enable it to play a more active role in settlement of such disputes. Fifthly, some experts have suggested that mediation can also be explored as a possible option for successful resolution of disputes. Then the final point is that the infrastructure should be created for better collection of data related to interstate river basins, because better data will provide clear picture regarding the availability of water, seasonal variation, and help in equitable distribution of water among states. As a conclusion, we can say the pressures of climate change become evident through water stress in various regions. So it becomes imperative that such disputes are settled in order to ensure optimal use of nation's water resources. So that is all about the article. So from this article, we saw about the reasons for persistence of interstate water disputes and the prevailing water dispute between the state of Karnataka and Tamil Nadu over Kaveri River, and then the way forward to deal with this. Now coming to the fourth article, law panel working on mechanism for simultaneous polls. The news reports that Law Commission is preparing grounds for simultaneous elections by working on a formula. The formula is set to synchronize all assembly polls by either extending or reducing the tenure so that all state elections can be held along with the Lok Sabha polls from 2029 onwards. So from this topic, let us know about Law Commission of India from prelims angle. First is regarding Law Commission of India. See, it is a non-statutory body and the Government of India constitutes it from time to time. The commission is established for a fixed tenure, and know that it works as an advisory body to the Ministry of Law and Justice. If we take the functions, the primary function of the Law Commission is to identify obsolete laws. That is, these are the laws which are no longer relevant and not in harmony with the existing environment. And other laws which require changes are also identified by the Law Commission. Secondly, it suggests suitable measures for quick redressal of citizens' grievances in the field of law. Then the Law Commission enables the poor to take benefits out of the legal process. Likewise, it examines the laws for promoting gender equality as well. However, know that the recommendations of the Law Commission are not binding on the government, and they are only recommendations, and the government or any concerned department may accept or they can even reject these recommendations. Now coming to the establishments of Law Commission, the first Law Commission was established during the British era. That was in the year 1834. It was established by the Charter Act of 1833 and it was chaired by Lord Macaulay. Then in the year 1955, the first Law Commission of Independent India was established for a 3-year term. Since then, 21 more commissions have been established. And in 2015, the 21st Law Commission of India was established, where its tenure was up to the month of August of 2018. And in the year 2020, the Union Cabinet approved the creation of 22nd Law Commission. Last year only, the Government of India constituted the 22nd Law Commission of India with the former Karnataka High Court Chief Justice Rituraj Avasthi as its chairperson. Fifth topic, electoral bonds to go on sale from October 4. Recently, the government announced the sale of electoral bonds from October 4 to 13 at all authorized branches of State Bank of India. So from this context, let us know about electoral bond scheme. Electoral bond scheme. See, the EBS is nothing but a financial instrument, and know that these bonds do not yield any interest. That is, they are non-interest bearing bonds. See, these electoral bonds allow eligible donors to pay eligible political parties using banks as intermediaries. That is, the donor who wishes to donate funds to a political party will have to buy this bond from the bank and pay a certain amount to the bank for this. The bank in turn will ask the political party to which the person has donated to come and encash it within a particular time period. The aim of this electoral bond is to ensure transparency and clean the political funding system in the country. If we take eligibility criteria for receiving and donating funds, the eligibility criteria for political parties have been separately mentioned. See, only the political parties that have been registered under the Section 29A of Representation of People Act of 1951 are eligible to receive funds. Secondly, these registered political parties should have got at least 1% votes or more than that in the last Lok Sabha election or the state assembly elections. Only then they can receive funds through electoral bonds. This is because only parties that are registered and actively taking part in politics can get donations, and those that are simply registered and are inactive cannot get donations. Thereby, any evasions or diversion of funds can be prevented. Also, the eligibility of donors is mentioned. It says that any citizen of India or entities incorporated or established in India can purchase these electoral bonds, which means that only Indians and companies registered in India can give political donations. Also, the citizens can buy these electoral bonds either singly or jointly with other individuals. Now let us see how this scheme functions. Know that only bank that issues is the State Bank of India. Also, it is issued only in months of January, April, July and October. Know that the electoral bonds are available in denominations from rupee 1000 to 1 crore. In addition to it, the donors can buy electoral bonds and transfer them into the accounts of political parties as a donation. But here, the name of the donor is kept very confidential. Only the SBI Bank and the Election Commission of India will be knowing the name of the person who has donated. For this reason, each political party will create a specific account and this account will be verified by the Election Commission of India. After that, whenever the political parties get donations, they will encash the electoral bonds only in this verified account. Know that the bonds will remain valid only for a period of 15 days. Within that time, the political party have to encash the electoral bond in that specific accounts. This is all about the scheme, but the question is that, has this scheme ensured any transparency in political funding? Let us find the answer to it by knowing the issues in it. Firstly, the problem of anonymity persists in the scheme. That is, in the electoral bond scheme, there is no provision that reveals the name of the donors of political party. This violates the freedom of political information, which is integral to Article 19(1) of the Constitution. So, as a result, those who contributed to whichever party will not be known to people who vote in the political process. Secondly, the challenges associated with the amendments of Finance Act 2017. The Election Commission points out various challenges in the Finance Act, like the amendments to Companies Act of 2013. In that amendment, the eligibility clause have been removed. The eligibility clause that existed before allows only a company which has a net average profit of 7.5% in last 3 financial years to make a political contribution. But this amendment has removed this eligibility clause. So now any company, even if it faces loss, can give donations to political party. Also, the ECI objects to this amendment by saying that this gives rise to creation of shell companies just to fund political parties. Further, this amendment will also give rise to issue of black money again in political funding. Secondly, the amendments made to Representation of People Act 1951 is another issue. By this amendment, the political parties now are not required to provide report to ECI regarding the donations they have received through electoral bonds. So this reduces the transparency in political funding, and further it prevents public scrutiny in democracy. Next is the amendment made to Foreign Contributions Regulation Act. This amendment permits the political parties to accept donations even from foreign companies. Hence, this is said to increase unchecked foreign funding to political parties in India. Further, this provision also threatens Indian policies as they might be influenced by foreign companies. These are few issues that need to be addressed to realize the objective of this scheme in practice. So here we discussed in detail about the electoral bond scheme as well as the issues which need to be sorted out. Coming to the previous year prelims question, this question was asked in the year 2018. Which one of the following best describes the term merchant discount rate sometimes seen in news? Options given are option A, the incentive given by a bank to a merchant for accepting payments through debit cards pertaining to that bank. Option B, the amount paid back by banks to their customers when they use debit cards for financial transactions for purchasing goods or services. Option C, the charge to a merchant by a bank for accepting payments from his customers through the bank's debit card. Option D, the incentive given by government to merchants for promoting digital payment by their customers through point of sale machines and debit cards. See, merchant discount rate is a fee which is charged by a bank from a merchant for accepting payments from merchants' customer through credit and debit cards in their establishments. So the answer for this question is option C. The merchant discount rate also compensates the card issuing bank, the lender, which puts the POS terminal and payment gateways such as MasterCard or Visa for their services. So we can say MDR charges are usually shared in pre-agreed proportions between the bank and the merchant and is expressed in the percentage of transaction amount. So it is a charge to a merchant imposed by banks for accepting payments from merchants' customers through banks' debit card is the answer. Now coming to the second question, Rule of Law Index is released by which of the following? The options given are option A, Amnesty International, option B, International Court of Justice, option C, the Office of UN Commissioner for Human Rights, option D, World Justice Project. This is a fact-based question. The answer for this question is option D, World Justice Project. The World Justice Project Rule of Law Index measures how the rule of law is experienced and perceived by the general public across the globe. And it is the world's leading source for original independent data on rule of law. So the answer for this question is option D, World Justice Project. With this, we have come to the end of news articles and previous year questions discussion. With this, let us wind up the discussion here. If you like the video and if you can understand the concepts well, please give like, share, comment and subscribe to ForumIAS Academy in various social media platforms for further updates. Thank you for listening.